All right. I am here with Dave Kennedy of Fidelity Land Title. Hey, Dave.
Hey, how are you?
Good. Hey, I have a burning question for you. And I know I learned it in real estate school, but I totally forgot. Okay.
I'm ready.
What? No, I'm just how much should an agent charge? No, I'm just kidding.
Right. Yeah.
What
A lot.
is, I know there's a lot of different ways that you could take title, but like
Mhm.
what are the differences and why does it matter?
Right. Yeah. So it's when you're taking title, it's very important because your title is kind of your ability to be able to access and use the land. Sometimes it gets complicated when you have more than one person taking title. So
Okay. I'd
there's
imagine
all
it's not that complicated if you're married, though.
no. Well, yeah, yes, yes
Okay.
and no. Yeah. So every circumstance is different. So typically there's two types of way that people take title when there's more than one person involved.
Okay.
One is with survivorship, and that's simple. It just means if there's one, two, three, four, five, whatever, however many people take title, if something were to happen to one of the individuals, then simply their interest would just go towards their undivided interest would just go to the next person. So if there's two people in title, one of them passes away, one half interest goes to the other person. The majority of people that are married are going to do with survivorship, and they're just going to have their interest go directly to the surviving spouse. Or sometimes if there's like family members, maybe there's mom, dad, and daughter, or daughter and son, that, and then they each have a quarter interest, then that interest gets divided in amongst the surviving people.
Okay. But what
That's
if
right.
you don't do that, then it would have to be dictated somehow in the will, right?
Right. Yeah. So if you don't do survivorship.
Yeah.
Yeah, so the other type of way that people take title is called tenants in common. And then
Okay.
that, yes, exactly. So what happens is after you die, you do your undivided interest does not just automatically go to whoever else is entitled. It goes through your estate. And then through your estate is where
Oh,
you can direct it. So a lot of times that'll be like if it's two business partners, if there's two or three
that
owners.
makes sense.
Yeah.
Okay.
And then so then if you each have, it's me and you owned a property and I passed
Oh, what are
away.
we buying?
Yeah, I don't know, something big. I
Something
don't know.
big. Lots of units.
I saw a nice big apartment building for sale down the road here.
All
So,
right, let's do it.
but my one half interest would then go towards whoever I would have in my will, and then you would still own your half interest, but then your other half would now be owned by
Whoever
whoever
was.
I direct it. So and again, you can have that kind of put however you
But
want.
I
There's
want to put like, so let me give you a scenario because I think this is like what used to be the confusing part for me is like just whoever's entitled doesn't necessarily have anything to do with the mortgage
correct.
or the
Yeah, I mean,
who
so
owes the money
so the mortgage, you know, is going to be, whoever is on the hook for, the
paying it
loan.
back,
A
right?
lot of times though, if say it's a situation like me and you have tenants in common and we both own 50% interest, the mortgage, a bank would be unlikely to loan you money on the loan for a full amount because you only really technically own one half of the
But
interest.
I've seen this more come up. Like, let's say there's two parties that are unmarried, but they are together, right? Just like, whatever. They're dating, but they're not married, but they
Right,
buy a house together.
right.
So
And one
if
person's on the mortgage because
one person's
somebody's
on the
credit's
mortgage, but
bad or
they're
something.
both, yeah, and they're both on the title. So then what
Yeah.
happens?
So typically what will happen still though is the spouse that's not on the hook for the loan, the person that hasn't signed the note will still have to sign the mortgage, releasing their dower interest. So saying that, well, even if it does get foreclosed on, I'm not going to get to keep my half. So you're still giving, it's still, if the bank's going to want to have, if they're going to be securing a loan against your property, they're going to want to at least be able to get their money back if you don't make your payments. So whoever's entitled a lot of times is still going to have to sign that mortgage, even though they're not personally responsible for the loan.
Yeah, but even if the real problem I see is like if you break up,
Hmm. Right. So I mean,
now if you're on the mortgage,
it, it,
if you're
it
the
gets
only one on the mortgage, but the other person is on the title, you got to get them off the title.
Yeah, and then there's a lot of times that, it gets real messy, at the
It's
end of a
super
relationship.
messy.
And another thing that we run into a lot of times with the problem is a couple is getting a divorce,
Right.
and they started the court process. They've already said, they say, okay, you can take the house, you can sell it, do whatever you want. But then technically, until a divorce decree is actually signed by the court, that spouse has to still sign on their mortgage. And a lot of times it becomes a big mess because they're like, well, we get to closing and we're like, hey, is your ex, soon to be ex-wife available to sign? Well, I didn't know she had to sign. The thing is until that decree is actually signed by the court, until you have a filed divorce decree, technically they're still married. Technically, the other spouse still has to sign that mortgage, releasing their interest. So, I mean, it gets awfully messy. So we always suggest to people that if you are going through divorce and you are either doing a refinance or you're selling the property, have the understanding that the other party is going to have to, sign if you're going to be buying something new, because that mortgage that you're signing to buy something new and you're still married, they're going to make you
It's still
sign.
part of your, yeah. The
Yeah.
other place where I see it gets messy is like parents and kids.
Mhm.
So it's like everybody will be on the title, but then like it just becomes so convoluted with all those people on the title,
Yeah.
and then if like one of the parties just goes like MIA, like say the kid just went off the rails and is now gone, like now what?
Well, they technically have, an interest in that property,
Yeah, and
and
you can't sell it.
you can't sell it because they have to have whoever there's, these
Oh
interests in
my
this property.
God.
So and that's just it. It's whoever takes title, has to come out of title in some way, whether that's, through death or if by signing off on, a new deed transferring your interest to the next party. So does get kind of complicated. It gets kind of messy, that anytime that you're buying something and you're still married, anytime that you sell a property, whoever's entitled is going to have to sign that deed. It gets kind of crazy. But that's why it's always good to do a little bit of planning at the very beginning. Like when we're
Right.
talking about, are you going to do it in survivorship? Is if two people are taking title, if one person dies, does it directly to the other person, or does it go to their estate?
Yeah, or just
That
think
means-
about like what happens if something went wrong,
right,
like
right.
what could happen and then kind of
So
work it from there.
it seems, I don't know. I only see the I guess the messes that get creative. But my suggestion would be is if you're not sure about that relationship, I don't know if I'd be buying property with someone unless
Or just buy one that you can afford by yourself. Yeah. Buy one that you can afford by yourself and then take title on it alone if you're the only one on the mortgage.
Right,
Like
right.
decide up front whose house, like even though it's your house together, like
Well, and something that you could do too is if you're both putting in, money and stuff, you could always, have the one person take title and, get a loan for a portion of it, and then another person, gives part of the money as well, and they put a second mortgage on it, a way to make sure
that
they get their
sounds
money back.
messy too.
Yeah, well, it's just like I said, when you're both entitled and it gets, you're both on the mortgage, and it can get kind of messy. So that's why it's always good to have good planning in place kind of ahead of time. It might be a good idea to meet with, an attorney or somebody that can
Right.
kind of direct you on what could go wrong, someone kind of playing devil's advocate on
Right.
everything. So
Right.
but the majority of the deeds that we do and see is that survivorship language. The only time typically it's not is, like you said, is if it's like a business relationship,
Right.
or if it's maybe like a brother and sister possibly, and they want their interest to go to their wife or their kids, or any of
That
that.
makes sense.
So it's
Yeah.
those types of situation. But for the most
God,
part,
you made it so much more interesting than real estate school. I think you
It's
should
fun.
rewrite that chapter.
I mean, sometimes the things we see is like straight out of what's it, Days of Our Lives or something, so and so's dead grandmother, and
Right.
there's a treasure chest in the basement and all kinds of
Jesus, that's fun. Well, Dave, remind us where Fidelity Land Title does title work.
Yeah, so we operate here in Cincinnati, but we cover all the surrounding states. We do the entire state of Ohio, Indiana, Kentucky, Tennessee, Michigan, Wisconsin, and Minnesota. So if you
Soon
ever
to
have
take
any,
over the world.
yeah, trying to one state at a time, one territory at a time.
Exactly. If people want to get in touch with you, what's the best way?
The best place to reach out to us is our website, fidelitylandtitle.com.
Awesome. Thanks, Dave.
All right, thanks for having me.
See ya.